Hi again. I've got an update on the preliminary injunction filed against the Corporate Transparency Act a week ago. And that is the DOD filed their notice of appeal in this case just 2 days after the December 3rd injunction. So you do not want to miss this update because I've got some surprising details that nobody else is talking about. There's a lot to be optimistic about, so stick around for a few minutes and see why there's good reason to think we will ultimately see long-term relief from this statute despite the government's best efforts at overstepping their constitutional authority. Today is Tuesday, December 10, 2024, and my report is ready to go. As always, this video contains only educational material and does not constitute legal or accounting advice. All opinions expressed are my own, so if you need legal or accounting advice, you'll need to consult your own lawyer or accountant. That said, let's get into it. If the DOJ gets their way and the injunction is stayed, FinCEN will enforce the BOI reporting requirements during litigation of their appeal and require all of us to submit our BOI reports while this process plays out. But today, I'm going to show you why I believe the government faces an uphill battle in their attempt to stay this injunction and restore the CTA's January 1st deadline. First of all, this appeal lands in the Eastern District of Texas, which is crucial to understanding what might happen next. You see, this court is in the Fifth Circuit, which is widely recognized as the most conservative federal appeals court in America. About 75% of its judges were appointed by Republican presidents, including 6 during the Trump administration. This court has consistently shown skepticism toward federal regulations and government oversight. They've become the go-to venue for businesses challenging federal regulations, with nearly 2/3 of all U.S. Chamber of Commerce lawsuits against federal regulations being filed in their jurisdiction. Second, I noticed the FinCEN website was finally updated, giving some hints about their position on the injunction and their attempt to appeal. There's a red notice at the top of their homepage that states, among other things, reporting companies are not currently required to file a BOIR and are not subject to liability if they fail to do so while the applicable order remains in force. And the order is in force while I'm recording this video despite the DOJ's notice of appeal. An article on their website provides even more insight, and here it is. There are a couple of quotes I find very interesting. First, reporting companies may continue to voluntarily submit beneficial ownership information reports. Why anyone would voluntarily give up their constitutional rights just to be on the safe side when FinCEN themselves tell us it is not required. Anyone who would voluntarily submit their personal information to the government shows that they do not understand how serious it is for our federal government to overstep their authority, and how this pushes the USA further and further away from the liberties guaranteed by the Constitution. But it happens. While the vast majority of CPAs and lawyers I've seen comment on this injunction advise not to file BOI report unless it's required, I've seen one popular CPA on YouTube encouraging people to do just that, file a BOI report even when it is not required. I could not disagree more with him. Here's something else in this article that provides insight as to the political motivations of FinCEN and the DOJ. This article says, the government continues to believe, consistent with the conclusions of U.S. district courts for the Eastern District of Virginia and the District of Oregon, that the CTA is constitutional. In considering this quote, you should take note that the Oregon District is considered a very liberal court and historically leans towards supporting government regulation, while the Virginia court is nearly the same. In fact, the Virginia court is located adjacent to Washington, D.C., and D.C. is perhaps the most left-leaning metro area in the USA, which votes more than 90% for Democrats, leftist policies, and more regulation instead of less. Also, Washington, D.C. is right across the Potomac River from Alexandria, where the Eastern District of Virginia Court is located. And Alexandria is more than 80% Democratic and historically votes in lockstep with Washington, D.C. I think it's safe to say that, of course, FinCEN is going to cite leftist and liberal pro-regulation decisions that typically lean heavily toward more government regulation and not less. Finally, I believe there's a decent chance this legal conflict may go all the way up to the Supreme Court. If that's the case, keep in mind that the current makeup of the Supreme Court is considered a 6-3 conservative court, with 6 of the Supreme Court justices inclined to an originalist interpretation of the Constitution. As you may know, the originalist constitutional view generally holds a conservative, anti-regulation, and anti-big government position. They tend to favor limitation on government control as envisioned by the founding fathers of the United States. Certainly, the CTA smacks of government overreach at its finest. Given this context, I believe there are 2 likely outcomes. First, I doubt the Fifth Circuit will grant the government's request for a stay, which means the injunction will stay in place for now. The court's track record suggests they'll be sympathetic to arguments about government overreach and skeptical of broad federal reporting requirements like those in the CTA. Second, if this case makes it all the way to the Supreme Court, it seems unlikely the CTA will survive that challenge. So, to be pragmatic, what does this mean for you? While I believe the motion to stay the injunction will fail, I still recommend maintaining a dual-track approach because, as of this recording date and time, the fate of the CTA remains unclear. So, make sure you gather beneficial ownership information and keep monitoring the situation closely. Of course, you can do that here by subscribing and hitting the notification bell because I'm monitoring this case for all my clients, newsletter subscribers, and YouTube viewers. That way, you'll be ready to file if circumstances change unexpectedly, and you'll be prepared regardless of the outcome of the current appeal. While I expect the January 1st deadline will remain suspended, this is still an evolving situation, and neither I nor anyone else knows the final outcome with any certainty. So again, if you haven't already done it, subscribe and hit the notification bell to stay informed about any breaking developments. Thanks again for watching, and I'll see you in the next video. And as always, have an awesome day.